Hey, welcome back, AP Government. Hopefully you're doing well. Still hanging on the home front here, Mr. Matthews' house. Still kind of getting through my own sickness. So hopefully you guys are staying healthy out there and you're not having to deal with any problems. But if you are, stay strong, keep getting your rest, drink lots of vitamin C, and he'll kick its tail here eventually. But it definitely takes a little bit of time to kind of get through any kind of flu virus, as you guys know. So anyway, bear with me here as my voice might be a little bit scratchy. But I wanted to have a chance to talk to you guys about some of the major Supreme Court cases that you need to know. There's 15 court cases that the AP College Board says that are essential. And what essentially you're going to have, and I'll start giving you some of these sample questions, are questions that are going to give you context of a case that you've never heard of or seen of before. And then you've got to apply it to one of these cases and talk about how they are similar. So I'll walk you through a bunch of those, but let's just kind of give you a quick overview. I'm going to give you a quiz on this video. So please make sure that you're watch video 41 so that you can do well in the quiz. So let's talk about the 15 court cases. Okay. Here they are, and this is straight off a College Board page. The key ones you need to know, the dates and all that. So we're going to kind of start in not in 100% this order, but we'll definitely cover all of them, and I'll give you some of the main takeaways from each of these court cases, okay? And keep in mind, we're going to continue to talk about these as we get into civil liberties and civil rights in the upcoming weeks, but it's always good to kind of know, okay, what is the course requirement so we can kind of start there, and then we can kind of build off on that and show you other cases that can relate to these where they could ask you them, right? So let's start off with McCulloch versus Maryland. This is one that we had back from Unit 1. The really big court case here is going to definitely deal with the Supremacy Clause, right? The idea that, the state, cannot tax a federal bank, right? So the Supremacy Clause is going to say that, okay, this bank can't get taxed by the state of Maryland, okay? But it also deals with the idea of the Necessary and Proper Clause, the implied powers, the idea that Congress can pass whatever law they want to, right? They have an incredible amount of power. And so the whole idea of being able to have a federal bank, even though it's not in the Constitution, that allowed them to be able to pass a federal bank if you want to. So Congress can create a bank. And again, this broadened the power of Congress. I like to think of McCulloch versus Maryland as kind of equivalent to Marbury versus Madison. Marbury versus Madison gave the judicial branch power. McCulloch versus Maryland breathes new life into the necessary and proper clause and into implied powers. They don't really tap into this an incredible amount, but as we'll see, especially going into the 1950s and beyond, Congress really starts tapping into this implied powers a lot more. Okay, let's go to the next one. U.S. versus Lopez. U.S. versus Lopez is the one with the guy who brought a gun to school, and he violated the Gun-Free School Zone Act of 1990. But they struck this down because the Commerce Clause. If you remember, the Commerce Clause is used in many ways to broaden the power of Congress. However, going to school is not commerce, right? You can't claim that as commercial activity. It's not like you have an option to go to school, right? It's a forced kind of compulsory attendance. So they struck down this law and they said bringing a gun to school was definitely a state crime, but it's not a federal crime. And I'll always compare this one to Heart of Atlanta. If you remember that one, Heart of Atlanta is going to be the court case that is going to basically legitimize the Civil Rights Act of 1964. And they say that law can be carried out by Congress because of interstates and the fact that businesses benefit from the infrastructure laid down by, federal laws and federal spending, that they can regulate business activity between the states. So Heart of Atlanta is going to use the Commerce Clause to uphold a law. In U.S. versus Lopez, they strike it down. So good kind of comparison, contrast there. Okay, Engel versus Vitale. This is the one where, going back in the 1960s, they would have a prayer that was basically read, and it wasn't like to, a specific God. It was to an all-powerful God, if you will. But still, the fact that it was compulsory school-led prayer, this is going to be struck down. And this is due to the Establishment Clause of the First Amendment. So there's two parts of the religious, freedom of religion, if you will. The first part is the Establishment Clause. And this is what really kind of brings about that wall of separation, the idea that, the government cannot have any kind of establishment or endorsement of religion. And the Engel versus Vitale definitely kind of crossed that barrier because it was compulsory, because it was mandatory to stand and recite this prayer. Okay. The other part, as we'll talk about in the next couple cases, is called the free exercise clause. And that's much more difficult to try to, like, infringe upon. Basically, the idea is, listen, you can practice your religion in any way you want to, but your rights ends where others begins. And so we'll talk about some limitations on that. So here's the free exercise clause of the First Amendment. This is going to be saying that, like, the Amish community did not have to go to school beyond the eighth grade, because this is what the state said, is that the court says that mandatory school attendance beyond the eighth grade was in violation of their ability to practice their religion. Obviously, their religion says that after eighth grade, you don't have to go to school anymore, and you can now be part of the farming community, if you will, and your school basically stops. So you can't force this community to go to school beyond the eighth grade. And of course, the idea is that they have free exercise. For the most part, you are allowed to practice your religion in any way you want to, right? I mean, as long as you don't violate the rights of others. And of course, this gets a little iffy, but this is where the Supreme Court has largely ruled in favor of freedom as opposed to restrictions. On the Establishment Clause, this is where it comes down to, like, can you really have a manger scene on state property? Right, like on city council's front lawn or something, or like in the town square. And this is where it gets a little iffier, obviously, because, like, that's an endorsement of religion. So if you allow for one religion, you have to allow for any religion that will then have their expressed kind of history day display, if you will, to represent their religion. So again, free exercise is going to be one where we see a little bit more freedom. The Establishment Clause, that's the one that kind of leads to that big division between church and state. Okay. Tinker versus Des Moines. This is the one that's going to say that you have the right to wear a black armband to protest the Vietnam War. And this is kind of silly, but during the time of the Vietnam War, kids would do different things to kind of show their protest. And one of the things they would do is wear a black armband. The school says you can't do that. They wore it anyway. And basically, the Tinkers are going to sue the school system and ultimately win on that, the idea that you get to have freedom of speech as students. Now, there's been a number of cases since then that kind of limit this. Bethel versus Frazier. Morse versus Frederick is one of my favorite ones. This is a one of a group of kids who, and like when the Olympic torch is running by their community, they all go out as a big school to kind of celebrate, right? Imagine like the Olympic torch kind of running by on Memorial Avenue right outside our school. So they're there, they all got signs, and a bunch of kids have signs, or at least one kid has a sign that says "Bong hits for Jesus." And that was a sign saying, hey, freedom of speech, right? Well, as you can imagine, Morse versus Frederick is going to be struck down. The kids do not get to have that kind of freedom. So largely the schools have ruled in favor of schools get to determine what's acceptable speech and not. But anyway, Tinker versus Des Moines was in the 1970s. We had a more liberal court then, ruled more in favor of the students. Okay. All right, New York Times versus U.S. This is the one dealing with what's called prior restraint. Prior restraint is basically the ability to have the freedom of the press. The government cannot step in and censor the press. Even if they have something completely classified, if they publish it, like, the federal government, I guess you could get in trouble for publishing, classified information, but if it's from an anonymous source, there's no way to really track it from. And that's usually where they get around this. But the government could not stop the New York Times from printing, again, classified information, the Pentagon Papers talking about the Vietnam War. And the idea that, listen, we are not going to ever tell the press what to do. Now, I guess there could be an issue of like national security where like the press could pull it back, but they typically don't have to. Prior restraint allows for the freedom of the press. If they get access to information, they can publish that. Even if it's kind of classified, even if it's one of those things where they're not supposed to, they'll just say it's from an anonymous source and they'll publish it. Schenck versus U.S. This is the one basically going to bring about the whole clear and present danger. It's basically a guy who was trying to caused a lot of problems during, I think it was World War I, but like burning the draft cards. And they said, you can't just advocate for burning of the draft cards. That could create a panic. And this is what sets up what's called the clear and present danger test. The idea that you can't yell fire in a movie theater because it creates a panic. You can't yell shark at the beach, right? Like freedom of speech covers a lot of areas, but if it's going to be public danger, it's not allowed. right? You can't yell bomb on an airplane, those kind of things. So there's what's a clear and present danger test established by Schenck versus US that says, actually, we can restrict that form of speech if it does cause some kind of danger. Okay, Gideon versus Wainwright, one of my favorite court cases here. Basically, the idea that you get to have a lawyer, right? You have the right to get an attorney, Gideon versus Wainwright. The idea that he was basically charged on this crime of breaking into a pool hall. He had a couple felony convictions prior, and he basically was given no lawyer because in Florida, you were only given a lawyer by the state if you were up for capital punishment. And so he had to defend himself, did a terrible job, and he actually goes to jail, and he's like, this is not right. I'm going to look into this idea that I get to have a lawyer. It is part of my rights. And he actually takes his little wooden pencil in prison and writes to the Supreme Court. He looks up like what provisions the Sixth Amendment should be able to be given to him. And he actually petitions the Supreme Court and says, I want you to hear my case. They do. And it's amazing. The ACLU defends him. In a 9-0 decision, Gideon is basically given another trial, found to be not guilty, found to be the main person who accused him was the person who actually committed the crime. It's a fascinating, fascinating story. But essentially what it means is that you have the right to an attorney, and the state has to provide you an attorney. Right. So this is why when we look at this is 1963, Gideon versus Wainwright, the right to an attorney. Miranda versus Arizona, by the way, is the one that you have to be read your Miranda rights. Right. And that's the idea that you have the right to remain silent. Right. You have the right to an attorney. That's 1966. So that happened after Gideon. So Gideon kind of laid the foundation to say you have the right to an attorney. Okay. All right, Roe v. Wade, this is the one that's going to involve a woman's right to have an abortion within the first trimester. The states can really not impose upon that, is what the courts have ruled. And there's been several cases trying to go at this again, if you will, trying to restrict different abortion clinics or trying to make it harder on the physicians that are there. Obviously, this is a very controversial topic, even to this day, and there's still cases that are on this that could come up even in this session. The Supreme Court's kind of ruled a gag order on much of this throughout much of the 1990s, saying we're not going to hear any cases. Now they're kind of hearing more cases on this. We'll see if there's any kind of change on this. But basically, it's women's right to an abortion, the Fourth Amendment, your right to privacy, and then the 14th Amendment is going to say that you can't tell a woman that she can't do this. The due process clause of the 14th Amendment is the idea that you have to be given your rights, and the states can't impose upon those rights. So we'll talk about the significance of the due process clause. Okay, McDonald versus Chicago. This is the one involving guns, and the idea like your Second Amendment rights, the idea that the state cannot just put an outright handgun ban. They can make it difficult to get guns, but this is the court case that we're going to talk about this process called selective incorporation. It brings the Second Amendment to the states. Because the Second Amendment, all the Bill of Rights were intended for the federal government. But over time, some of these have been applied to the states. And this is a process called selective incorporation. And it's through that due process clause of the 14th Amendment. Again, I'll get into it more when we get into civil rights and civil liberties and whatnot. But this is the one that applied the Second Amendment, saying that a state can make it difficult to get a gun, but they can't outright put a ban on your ability to have a gun. And that struck down the handgun ban in Chicago. All right, Brown versus Board of Education, probably the most famous court case, an extremely significant landmark Supreme Court case, is going to overturn Plessy versus Ferguson. It's based on the Equal Protection Clause, of the 14th Amendment, which basically says that all civil rights cases, by the way, fall under the Equal Protection Clause. The idea that citizens must be treated equally and that you can't discriminate against them. So we'll talk a lot more about that because this is civil rights case 101 right here. Obergefell versus Hodges, the Supreme Court case that allowed for gay marriage, also falls under the Equal Protection Clause, right? The idea that states cannot discriminate against, people based on their sexual orientation who they want to marry. So Brown's a big one, and we'll talk more about that. Citizens United versus FEC, we've come across this one already. Again, there's a lot to this one, but basically the idea that you have the freedom of speech as a corporation, as a group of individuals to campaign in these independent expenditures, just like individuals do, right? And of course, they had to create super PACs that allowed for this. But again, it's the idea of freedom of speech is going to allow this And as we look at like the changes that took place from the BCRA and to this one, it's basically going to take away a lot of those restrictions, right? Now you can give money. Now you can even endorse candidates as well, because under the BCRA there was limitations imposed on that, and they're basically going to say no. Political speech is freedom of speech, and they really lift a lot of those issues that those ads were falling under 527 guidelines. Now, super PACs can absolutely come out and endorse candidates. They can come out and say whatever they want to say because it's freedom of speech. So this is a major court case that really empowered organizations and outside groups to be able to campaign on behalf of candidates. Right? They can't give money directly to candidates, but they can have independent expenditures that they can create to support them. Okay, a few more here, guys. I think it's my last slide, so bear with me. We have maybe Marbury versus Madison. Haven't covered that one yet, so maybe one more after this slide. Baker versus Carr. We covered this one already. Baker versus Carr is the one man, one vote principle. The idea that you must redraw your districts every 10 years because population changes. And again, based on the Equal Protection Clause, make sure that citizens are given that equal representation. Shaw versus Reno, again, also based on the Equal Protection Clause, but this allows for majority minority districts to exist, right? So this is a really big one because the one that kind of established those kind of really weird districts in outside Chicago, North Carolina also has majority minority districts. States are allowed to draw these really, really odd shaped districts if it gives minority groups representation to make sure that Congress is representative of the population. Okay, and obviously the last one here, this is the one that we talk about with the Hulk, right? Marbury versus Madison. It set the precedent of judicial review, the ability for the Supreme Court to overturn and look at the constitutionality of law. If you know the details of this one, essentially there were all these midnight judges, and these appointments were being made right as Adams is leaving and Jefferson is coming in, and Marbury is supposed to get this judgeship, and he doesn't. Madison was the Secretary of State at the time, doesn't deliver it, so Marbury is suing Madison. It starts at the Supreme Court, and they're basically like, listen, there's a writ of mandamus that says the Supreme Court can come in and basically tell Madison to give Marbury this judgeship. Supreme Court kind of does something odd. They kind of step out of this one and they say, well, actually, that part of the Judiciary Act of 1789 is unconstitutional. And in doing that, they kind of like get themselves almost a leverage over Congress, because they're like, not only can we declare that law is unconstitutional, right, the Judiciary Act of 1789, the writ of mandamus, but we can now say any law is unconstitutional, right? We can tap into this power of judicial review that was really kind of like seen in Federalist 78. We'll read that Federalist paper. It's seen a little bit in the Constitution, right? They have the ability to review all laws, treaties, and whatnot. This just breathes new life into it. So now the Supreme Court can step up and say, hey, we have one superpower, but it's a major one, and we can strike down any law that we want. Okay, guys, I'll stop there for this video. Hopefully that's helpful. Please watch video 41 again and again for your quiz, and I'll give you some documents to help you out on this one. But thanks for watching, guys. We'll talk to you very soon.